What if I don't agree? Educational setting concerns, disagreement resolution, appealing an EHCP decision, disability discrimination appeals, school exclusion appeals, local government and social care ombudsman. What if I do not agree with decisions about SEN provision? This information is about what you can do if your child or young person has special educational needs or a disability and you are unhappy about the help being given in schools, including non-maintained special schools, further education colleges and sixth form colleges, academies including free schools, university technical colleges and studio schools, specialist resource bases, independent schools and independent specialist providers approved under Section 41 of the Children and Families Act 2014, all early years providers in the maintained, private, voluntary and independent sectors that are funded by the local authority. Concerns related to an educational setting. The first step is to talk to the teacher or tutor. If you need to discuss things further, you can speak to the head teacher or course director, or to the Special Educational Needs Coordinator, SENCO. We would advise that you ask for a meeting at the setting to discuss your concerns. It might be helpful to ask a friend or relative to attend a meeting with you. It is a good idea to keep notes or have records of what they have done and have told you. We have a send planner template in the booklet section of our website which may help. If you think that the setting could do more, you can complain using the complaints procedure available on their website or ask them for a copy. If you have followed the setting's complaint procedures and you are unhappy with the outcome, the next step would be to complain to the Department for Education, or DfE, if you are complaining about a maintained school, or the Education and Skills Funding Agency, ESFA, an executive agency of the Department for Education, if you are complaining about an academy, a free school, a college or an apprenticeship provider. Disagreement Resolution Services. The Disagreement Resolution Service is there to help resolve disagreements between parents or young people and the organisations that are responsible for making provision for children and young people with special educational needs. Disagreement resolution is voluntary for all parties. A parent or young person can ask for disagreement resolution at any time during the SEND process. The dispute can be about education, health or social care provision. Access to disagreement resolution covers all children and young people with SEND, whether or not they have an education, health and care plan, EHCP. Disagreement resolution meetings are conducted in the same way as mediation meetings. Mediators manage the meeting and make sure that everyone is fully heard and treated fairly. They ensure that the focus of the meeting stays on the needs of the child or young person. In Norfolk, this service is provided by Kids. They are independent and will provide a trained mediator to facilitate a discussion. The purpose is to look for a way forward that all parties accept. The service is free and confidential. You can contact Kids SEND Mediation and Disagreement Resolution Service on 0330 062 835. What to look for in a draft EHCP. It is important that the EHCP is correct and describes your child or young person clearly. It must describe what the special educational needs of your child or young person are, what special educational provision they require to meet those needs, and what the agreed outcomes are for your child or young person. All special educational needs provision and outcomes must be specified in an EHCP. The use of vague words should be avoided, such as regular, access to, or opportunities for. It should be clear who has to do what, when, and how often. It will not name a specific person, but should state the job role, the training needed, etc. Check basic details such as correct spelling of names and the right date of birth. Sometimes spelling and typing errors slip in. Make sure that it says everything you think is important about your child or young person. Do you recognise your child or young person? There shouldn't be any surprises. In preparing the draft, the local authority uses the information and reports that they have received as part of the needs assessment. And with the draft EHCP, you will have received all the reports, evidence collected during the assessment. These will be listed in section K of the plan, so you can check that you have them all. The SEND Code of Practice says, parents and young people can appeal to the SENDIST Tribunal about a decision by a local authority not to carry out an EHC needs assessment or reassessment, a decision by a local authority that it is not necessary to issue an EHCP following an assessment, the description of a child or young person's SEN specified in an EHCP, the special educational provision specified, or the school or other institution or type of school, such as a mainstream school or college, specified in the plan, or that no school or other institution is specified. An amendment to these elements of the EHCP, a decision by a local authority not to amend an EHCP following a review or reassessment, and a decision by the local authority to cease. Appealing an EHCP decision to SENDIST. If you wish to register an appeal with the first tier tribunal, SEN and disability, you first have to consider whether to take part in mediation. This is called Mediation Information Advice Session, or MIAS. If you decide not to use mediation after discussing the options, tell the mediation advisor. They will send you a certificate within 3 working days, and you can then register your appeal. You do not have to use mediation if you do not want to. You only have to consider whether to or not. The local authority must tell you about mediation and who to contact for the initial advice when they send you their decision. You must contact the mediation advisor at KIDS within 2 months of getting the decision from the local authority. There are 2 exceptions to this rule. You can register an appeal without considering mediation first if the appeal is only about the name of the school or college named in section I of the plan, the type of school or college specified in the plan, or the fact that no school or other institution is named. It is a disability discrimination appeal. If you choose mediation, the local authority must take part. The meeting will be arranged within 30 days. An independent mediator runs the meeting. When the meeting has finished, the mediator issues you with a certificate within 3 working days. You need the certificate if you still want to register an appeal with the first tier tribunal. You have 2 months from the date of the final EHCP or the final EHCP after an annual review, the decision letter following an annual review, decision to cease or maintain, or 1 month from the date on the mediation certificate, whichever is the later. Mediators must be trained and accredited and are independent of the local authority and clinical commissioning group. This service is provided in Norfolk by KIDS Mediation Service. You can download the correct form from the SENDIST website. Form 35 is refusal to issue an EHCP, appeal section B, F and I, and health and social care recommendations. Form 35A is refusal to assess for EHCP. Photocopy the paperwork you are asked to provide and send to SENDIST by email or post. Ensure you read through all the paperwork that comes back from the tribunal and keep a record of all important dates. It is helpful to continue to discuss changes and options with the local authority to see if a decision can be made which you all agree on. You can withdraw the appeal once you have changes in writing. The SENDIST website has helpful videos on what to expect at a tribunal hearing. The SENDIST Disability Discrimination Appeal. Before your appeal, you need to prepare your claim. This involves gathering as much evidence as possible to support your case. There is a time limit for making a claim. The claim must be received by the tribunal within 6 months of the last act of alleged discrimination. The tribunal will first decide if the child or young person has a disability as described by the Equality Act 2010 before going further with the claim. If you are making an appeal against a private nursery, further education college or a local authority, this would need to be brought in the county court. If you wish to bring a claim in the county court, you will need to seek advice from a solicitor. Please see our disability discrimination booklet available on our website. You can download the correct form from the SENDIST website. Send 4A, claimed by a parent, or send 4B, claimed by a young person. First Tier Tribunal, SEND. You can contact them on 01325 289 350. You can email them sendistqueries@hmcs.gsi.gov.uk, or you can visit their website www.gov.uk/courts/tribunals/first tier tribunal special educational needs and disability. Appealing a school exclusion. You can appeal against a school exclusion and your case can be put forward to the governing body of the school. For a fixed term exclusion of less than 5 days, they do not have to meet with you but must consider your views. If the governors agree with the permanent exclusion, you may then ask the school for an independent review panel, IRP, within 15 school days. If you feel your child's SEN is relevant to the exclusion, you may request that the local authority or Academy of Trust appoint an SEN expert to attend the review. The IRP panel is set up by the local authority and must have 3 or 5 members. The hearing must be held within 15 school days after the notice of appeal is received by the school. You are entitled to take a friend or advocate. You can find out more in our exclusions booklet available on our website. Local Government and Social Care Ombudsman and Judicial Review. The Local Government and Social Care Ombudsman, LGSCO, investigates complaints which have not been resolved by the local authority complaints procedure and consider if the correct actions and procedures have been followed. There is an expectation that you will have followed the local authority complaints procedure first before going to the LGSCO. If the case is serious and the child is missing education, then the LGSCO may start assessing before going to the local authority. See the SEND Code of Practice, paragraph 11.89 on our website under Legislation and Guidance. If the LGSCO finds the local authority is at fault, they can ask them to reconsider and make recommendations. These recommendations can include compensation or an apology. The local authority does not have to carry out the recommendations, but they usually do. Parents and young people can apply to have their concerns taken to judicial review, High Court. It will consider how the local authority and public bodies have carried out duties, for example, how decisions were made in an EHCP, or failure to provide a provision outlined in the EHCP. The cost of going to judicial review can be very high if a case goes ahead. You may be able to obtain funding through legal aid. If you disagree with how the local authority has acted and would like to make a complaint, you can contact them on 0344 800 8020 or visit www.norfolk.gov.uk. Local Government and Social Care Ombudsman. Check if you are eligible for legal aid. www.gov.uk/check legal aid. You can contact us on 01603 704070, text us on 078 600 33614, email us at sendpartnership.iass@norfolk.gov.uk, or visit our website at www.norfolksendpartnership iass.org.uk.